Good day, Crime Talk aficionados. We have a huge show for you today. First, Kohberger's reply brief is filed and the defense wants it kept secret. The Karen Reed murder trial. Well, the jury's deliberations continue amid defense concerns. We have an analysis of the Vance Boelter case, charges, suspect, capture evidence, involvement of other crimes, and possible motives. Why are all these bar shootings about respect? An update on the manhunt for Travis Decker. A federal judge dismisses a juror in the Sean Diddy Combs sex trafficking trial amid residency concerns. An attorney was sanctioned in the Jennifer Crumley case. We'll talk about that. We have also Donna Adelson. She wants a change of venue. This day in legal history. Our legal quote of the day has to do with free speech and its limits. And our dumb criminal of the day, Hassan Rabbit Rabat's wedding day blunder. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich. Thanks for joining us. This is Crime Talk. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. Now, before we get going, let me remind you to go to crimetalksearch.com and sign up for that background subscription service today. When you do, you'll be able to do as many background searches on anyone here in the United States as your heart desires while you have the subscription. And remember, you can cancel at any time. So whether you want to do one search or 1,000 searches, this is the service for you. Now, you will literally get a report emailed to you while you wait, and it's going to have all types of information that you probably didn't even think about looking at for a person. You're going to find out phone numbers associated with this individual. You're going to find out their social media presence, email addresses. Do they have a criminal history? Are they married? Are they divorced? Do they own property? Do they have judgments against them? Do they have to put themselves on one of those sex offender registries? Yes, ladies and gentlemen, everything you want to know about somebody that maybe you're just not going to come right out and ask them, or they're not going to come tell you, go check them out. It literally could save your life. All right, let's go ahead and open the record for June 16th, 2025. And before we get started, let me just say happy birthday to the lovely Miss Kristen. Yesterday was her birthday, and hopefully she enjoyed it. It was a great day. Happy birthday. And also for all the fathers out there or people who have fathers, hopefully you were able to say hi and wish them a happy Father's Day as well. All right, let's go ahead and get to the docket. So opening the record. First, Brian Kohberger. The Kohberger attorneys file their reply brief to the third-party perpetrator issue. And why do they want to keep it a secret? So the defense requests to seal the motion regarding their alternate perpetrator evidence in the Brian Kohberger case likely stems from strategic legal considerations, even if they believe that the alternate perpetrator exists. So let's kind of discuss the primary reasons why the defense might prefer to keep this information confidential based upon legal principles and the context of the case while maintaining, obviously professionalism throughout this, right? Now, you would think if your client is charged with murder and you had proof that your client was absolutely innocent and you knew who did it and you had enough evidence to convince a judge that this is the suspect, go arrest this person, you would be yelling it from the mountaintops to get your client out of custody, right? You would think so. I once remember we were involved in some civil litigation, and it was a conspiracy case. And literally, we had the smoking gun conspiracy email. Guess what we did? We attached that email to every motion we had so that it was out there for the world to see that this was the conspiracy, and this is why there needed to be a finding of, responsible, and that they should pay. All right. I would think if this was the case where my client was innocent, let me show you the data to show this is the person who is responsible for these murders. But that's not what they're doing. So let's talk about maybe possible defense strategy. The defense may wish to avoid prematurely disclosing their alternate perpetrator theory to the prosecution or to the public. Now, understand the prosecution has already received at least a glimpse of it because they've been able to respond, and this is a reply to their response. We'll have to see where that comes up. Anyway, revealing such evidence too early could allow the prosecution to prepare counter arguments and obviously gather rebuttal evidence, potentially weakening the defense case at trial. But they have to do that. So why not let us have it out there? And by sealing the motion, the defense ensures that their strategy remains confidential until maybe presented in court, where it can be introduced with the maximum impact to support reasonable doubt. Now, this approach aligns with standard legal practices of safeguarding tactical advantages. It does. But like I said, if you think your client's innocent, wouldn't you want that information out there? Yes. I mean, just oftentimes, sometimes you got to know when to hold them, know when to fold them, and know when to run, right? Sometimes you want to hold your evidence close to your vest if you absolutely know you're going to go to trial. But once again, and I had this happen recently where the DA was like, oh, why don't you just give us what you got so we don't have to go through a 1-month trial like we did last time? And I was like, okay. And guess what? They ultimately made a very reasonable offer when it was determined that a witness has basically been shaking down my client for money to not show up at court. Yes, completely inappropriate on the part of a victim. So sometimes you never know, but if you know that they're doing it, turn that information over. I mean, I would like to think that the prosecution, any prosecutor, would not want to prosecute an innocent man if that evidence exists. So if it exists, go give it to the prosecutor and let them see where the case goes. But that's not what's taking place. All right, next, the Kohberger case has obviously attracted significant media attention, which could amplify any publicly disclosed details about an alternate perpetrator. And if the defense evidence or allegations were made public, obviously it would lead to speculation, potential misinformation, or attempts to identify the alleged alternate perpetrator, potentially compromising the investigation or influencing potential jurors. And sealing the motion helps obviously mitigate the risk of prejudicial publicity that could affect the fairness of the trial, as noted by Judge Hippler's concerns about media leaks complicating jury selection. Next, we have the motion to seal for secret and sensitive information is this darn Idaho Court Administrative Rule 32, which allows the sealings to protect confidential information such as ongoing investigations, or private personal data. And the alternate perpetrator evidence may involve sensitive details such as witness identities, investigative tips, or forensic analysis that could be jeopardized or even compromised if disclosed publicly. For example, the defense has previously referenced a tip about another suspect and an expert opinion that the crime required at least 2 perpetrators, which may involve protected investigative materials. And obviously the biggest one is, well, we don't want to harm third parties, right? If the defense's alternate perpetrator theory points to a specific individual or group, public disclosure could harm innocent parties by subjecting them to public scrutiny or harassment. Even if the evidence is speculative or inadmissible, as Judge Hippler suggested it very well might be, naming or implying another suspect could lead to reputational damage or safety concerns, and sealing the motion minimizes the risk while the court evaluates the evidence admissibility. And then also we've got the judge has expressed skepticism about the admissibility of the defense alternate perpetrator claims, noting that much of the submitted material was potentially fairly objectionable and required actionable evidence. Now, the defense may prefer to keep these filings sealed to avoid public or media criticism if the evidence is deemed weak and inadmissible. And obviously, by maintaining the confidentiality, they can refine their argument without external pressure until the June 18th hearing, which obviously is coming up in 2 days. And of course, you got to comply with the court's order, right? The motion notes that the materials were previously sealed, suggesting that the defense is adhering to existing court directives to maintain consistency. And this compliance reflects a procedural necessity to protect information already deemed confidential by the court and reinforcing the legal basis under this pesky Rule 32. So ultimately, defense request to seal is likely driven by the combination of strategy, procedural, and ethical considerations. While the notion of a real killer being at large might suggest a public interest in disclosure, the defense prioritizes protecting their client's right to a fair trial, preserving the integrity of their evidence, and minimizing external inferences. These actions are consistent with the standard legal practices in high-profile cases, and particularly given the court's emphasis on managing prejudicial publicity and ensuring admissible evidence. I sure would love to know, though, wouldn't you? Wouldn't you love to know? I mean, you would think if there's the real killer is out there, shouldn't we go arrest the guy? Or maybe it's so weak and speculative, the judge is going to say, I couldn't even issue probable cause. Because if you go back to our archives about 2 weeks ago, we did a story about what was the legal standard for the admissibility of alternate perpetrator information, suspect information at trial. And it is a very tough legal burden. And I'm not saying that because I don't want it to come in. I mean, we want the truth to come out, bottom line. But it is a tough legal burden. You have a better option with just going a general denial defense and saying, wasn't my guy, can't prove it. Basically, that's it. But I would love to know. I would love to know what the basis for this is. And hopefully it will be unsealed. My guess is, though, probably after trial. Next on the docket, the Karen Reed murder trial. Jury deliberations continue amid defense concerns. Now, ladies and gentlemen, you have to remember this was a 33-day trial, I do believe, 33 days. They deliberated about 3 to 4 hours on Friday, and they've deliberated today. It's about almost, 3:45 Eastern time at the time that we are doing this filming of this show for today. That's not a long time considering all of the evidence that they need to consider. Now, also, a lot of people are saying it's so obvious it should be a not guilty. Well, generally, if it's going to be a not guilty verdict, it usually comes back pretty fast. Okay. But you have to remember that would be the simple verdict if it was like a 1-day trial. This was a 33-day trial. Done lots of jury trials. One thing I am absolutely convinced of, the jury will take their jobs very seriously and they will make the best decision that they can. And that's why I will respect whatever decision the jury makes because they're the ones that are making it. Okay. For most of these jurors, this, other than maybe getting married, having children, buying a home, this will be one of the biggest decisions that they will ever have to make. Why? Because it affects somebody's potential loss of liberty. Let them take their time. Okay. And whether it's a guilty to all charges, maybe a guilty to lesser included, or not guilty to all, or not guilty to some, or even a hung jury, ladies and gentlemen, the reality of it is respect the jury. Whatever the decision comes back as, go with that. All right. So obviously the case of Karen Reed, where she is accused of killing her boyfriend, John O'Keefe, back in January of 2022, entered a critical phase as the jury deliberations resumed today. And the courtroom video feed was disabled during deliberations with broadcast set to resume only for judicial proceedings, such as a jury question or the announcement of a verdict. Now, Miss Reed is charged with second-degree murder, manslaughter while operating under the influence, and leaving the scene of a fatal accident, faces allegations that she struck O'Keefe with her Lexus SUV and left him to die in a snowstorm. Now, the prosecution, led by Special Prosecutor Hank Brennan, argued that Reed was intoxicated after a night of heavy drinking, hit O'Keefe, and fled. In contrast, the defense, Alan Jackson, contends that O'Keefe was killed in a fight and somehow dragged outside of the home that he maybe never went into, accusing police of conducting a corrupt investigation. Oh, and don't forget, obviously the dog created those wounds. That's for the jury to decide, ladies and gentlemen. Anyway, for those who missed it, last Friday were closing arguments followed by approximately 90 minutes of deliberations before jurors adjourned for the weekend. Now, the Judge Cannoni, instructed attorneys to remain within 5 minutes of the courthouse, anticipating a swift verdict. Reading expected within an hour of the decision. Now, that's normal for the judge to say, listen, we've inconvenienced this jury enough. I don't want to be having to chase down attorneys or victims that are allowed to be in the courtroom. So stay close. Stay close. Okay? Anyway, and the other thing is, I can tell you, ladies and gentlemen, I've taken a lot of verdicts over the years, ladies and gentlemen. I can tell you the worst moment, I don't care if it's a simple case or a homicide case, when they say that we have a verdict, stomach just sinks every time. And then, of course, you start second guessing yourself. Did I do enough? I shouldn't have done this. I shouldn't have done that. And you don't know. And then the jury comes out. And then the question is, can you read what the jury's going to say? Most of the time, you can't. Now, if you got a happy verdict, if you have a happy jury, my experience is it's not guilty. If it's a somber jury, they have found your client guilty of something. And, it's going to be downhill from there. Like I said, we just have to wait and see. But I always like when you can hear back in the jury room when you're waiting for everybody to assemble in the courtroom and the jurors are back there laughing. Ha, 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 ha. Because, it's kind of their way of sticking it to the man. You know what I'm saying? Anyway, it's all good. Anyway, so Reed's defense team filed a motion to amend the manslaughter verdict form, or the slip as they call it there in Massachusetts, arguing that its design could confuse jurors and bias them towards a guilty verdict. Now, the current slip lists 4 guilty options, but only 1 not guilty option for the manslaughter charge, which the defense claimed visually favors conviction. Well, the judge didn't even need to hear from the prosecution, denied that motion without a hearing, stating the slip complies with Massachusetts law and their standard slip forms or jury verdict forms. Anyway, for those who aren't familiar with this case, this retrial began back on April 22nd, following a mistrial back in 2024, when a hung jury failed to reach a verdict after 27 hours of deliberation. And obviously, the case has gained a lot of significant attention for its conflicting narratives and allegations of investigative misconduct. As deliberations continue, the public awaits the resolution of this very contentious case. And remember, we too are on verdict watch here in the Karen Reed case, and as soon as it comes up, well, we'll let you know. So you probably want to have your little notifications so that you receive the notification that we're going live. Because if I'm here, guess what? We're going to be here talking about it. But sometimes I got to go do work, and so out of the office, so that may not necessarily come to fruition, but we're going to do our best. Next on the docket, let's talk about this Luther Boelter guy. He is a 57-year-old resident of Green Isle, Minnesota, and he was arrested on June 15th following a 2-day manhunt described as the largest in Minnesota's history. Now, he is accused of targeted killings of Minnesota State Representatives Melissa Hortman and her husband, Mark Hortman, and the attempted murder of State Senator John Hoffman and his wife, Yvette Hoffman, in the late hours of June 14th. Now, the attacks, labeled as politically motivated assassinations by the Minnesota Governor Tim Walz, occurred in the Minneapolis suburbs of Brooklyn Park and Champlain. I'm going to try to provide a comprehensive examination of the charges, the suspect's background, the circumstances of his capture, and the evidence linking him to the crimes, the potential involvement of others, and the possible motives. All right. So first, state charges. Boelter faces the following charges in the Hennepin County District Court, as outlined in a criminal complaint unsealed after his arrest. 2 counts of second-degree murder with the intent, not premeditation, for the killings of Melissa Hortman and Mark Hortman. Each count carries a maximum sentence of 40 years in prison with a mandatory minimum of 3 years due to the use of a firearm. 2 counts of second-degree attempted murder for the shooting of John Hoffman and his wife, Yvette. Each count also carries a maximum sentence of 40 years. Now, on June 16th, today, the Hennepin County Attorney Mary Moriarty announced the intent to pursue first-degree murder charges, which require premeditation and carry a mandatory sentence of life without the possibility of parole there in Minnesota. Now, the initial second-degree charges were filed to secure a nationwide arrest warrant quickly, a common procedural practice, and obviously the upgrading to the first-degree murder charges will require a grand jury indictment there. And the district attorney indicated that the investigation is still in its early stages, with evidence review expected to take some time. Now, Minnesota abolished the death penalty in 1911, so execution's not possible under state law. But wait, there's always the feds. Federal prosecutors have filed a 6-count complaint, which will obviously have to be followed up by an indictment as well. And the acting United States attorney said these charges may take precedent over state charges. First, they're going to charge stalking for Melissa Hortman using interstate commerce, the maximum sentence of life in prison. Stalking of John Hoffman, maximum sentence of 20 years. Murder of Melissa Hortman with a firearm, maximum sentence, death or life in prison. And that obviously they have to seek the death penalty. And for the murder of Mark Hortman with a firearm, maximum sentence is death as well. Throw in a couple of firearm offenses, you got another life sentence in there. Firearm offenses in the shooting of John and Yvette Hoffman, sentence life in prison. The federal charges reflect the severity of the crime, particularly due to the premeditated nature of the attacks and the use of interstate commerce. For example, researching the victims online. Yes, that's all it takes, ladies and gentlemen. And unlike Minnesota state law, federal law permits the death penalty for first-degree murder or terrorism-related charges. However, Thompson did not confirm whether the prosecutors would seek the capital punishment. That's the acting United States attorney, leaving the possibility open. Now, Boelter's federal charges stem from the FBI investigation, which highlighted his planning and targeting of elected officials. And needless to say, he's not going anywhere anytime soon. Although the state set bail at $5 million, it's unlikely that he will get a bond in the federal case. He was scheduled to appear simultaneous court appearances on June 16th via virtual appearances for state charges at the Hennepin County Public Safety Facility in Minneapolis and an in-person appearance in federal courthouse at the federal courthouse in St. Paul. He's currently in federal custody under a U.S. Marshal's hold with no bond specified for those charges. He's not going anywhere, ladies and gentlemen. And the feds are going to keep him. And if, when the feds are done with him, they'll more than likely send him back to the state as well. So what do we know about this guy other than he's a cold-blooded killer? Well, we know he's 57 years old. He's a Minnesota resident with a complex background in security, some workforce development, and nonprofit activities. We know that he worked as the director of a security patrols for Praetorian Guard Security Services, a company registered by his wife in Green Isle, which is Sibley County up there. And he claimed training from U.S. military personnel and had an extensive background in security. He also worked in the funeral home industry, performing removal for the Hennepin County Medical Examiner's Office, and previously held a job extracting eyeballs from cadavers for organ donation. Now, Boelter was appointed by the Minnesota Governor's Workforce Development Board back in 2016 by then Governor Mark Dayton and reappointed by Tim Walz, serving until 2023. Now, this is a 60-member advisory board that analyzes workforce policies, and Boelter served alongside Senator John Hoffman, though it's unclear if they ever had any personal relationship. Now, Boelter is listed as the president of the nonprofit You Give Them Something to Eat, which references a biblical story but reported no income or spending. He and his wife also led Reformation Ministries, where he was ordained as a reverend in 1993. He has an online presence, suggested connection to religious groups, and travel to conflict zones like the Gaza Strip and the West Bank pre 9/11. Boelter is married, a father, and registered as a Republican voter in the early 2000s. He texted friends around 6 a.m. on June 14th, apologizing for his actions and suggesting he might die soon, indicating awareness of the gravity of his actions. Now, Boelter's professional and religious affiliations, combined with his access to firearms and security training, kind of paint a picture of an individual with the means and knowledge to execute a sophisticated attack. His political appointment and Republican voter registration have raised questions about his motives, particularly given the Democrat affiliation of his victims. We just don't know yet. Some people said that he was Republican, then he switched to back and forth, and really doesn't matter. And those boards, whether you're a Democrat or Republican, the governor never meets or interviews you. You're just kind of looked at and somebody recommends it, and the governor signs it. So I wouldn't put a whole lot of weight into that. Once we get this guy's manifesto, obviously it'll be a little more interesting to see a motive. Anyway, so how was he caught? So the manhunt for Boelter, spanning over 43 hours from the 14th of June through the 15th, involved hundreds of law enforcement officers, more than 20 SWAT teams, surveillance aircraft, and the Minnesota State Patrol helicopter. So what really went down? So on June 14th at approximately 3:35 a.m., the Brooklyn Park police arrived at the Hortman residence for a welfare check after learning of the Hoffman shooting. Officers witnessed Boelter shoot Mark Hortman through an open door, exchanged gunfire with him, and saw him flee into the home before escaping on foot. He left behind a Ford SUV modified with police-style lights. Then on June 15th, police located a black Buick sedan registered to Boelter and one of his daughters, abandoned in a field near Highway 25 and 301st Avenue in Faxon Township, or in Minnesota, which is apparently close to his Green Isle home. A hat believed to be Boelter's was also found nearby, reinforcing suspicion that he was in the area. Then a trail camera captured a clear image of Boelter in the woods near Green Isle on June 15th, prompting police to establish a large perimeter. A police officer reported seeing him running into the woods, triggering an intensive search. Late on June 15th, Boelter was found crawling in a field near his home. He was armed but surrendered without incident, crawling to officers to be handcuffed. Now, the Minnesota State Patrol Lieutenant Colonel Jeremy Geiger described the arrest as peaceful with no shots fired. Boelter was then booked into the Hennepin County Jail at about 1:02 a.m. Today and transferred to federal custody shortly thereafter. Now, this manhunt scale involving coordinating across local, state, and federal agencies underscored the urgencies to apprehend Boelter given the high-profile nature of the victims and the potential for further violence, indicating his hit list. So, what other evidence do we have here? So apparently there's multiple pieces of evidence strongly implicating Boelter as the perpetrator. First, we got eyewitness and surveillance footage. The Brooklyn Park police witnessed Boelter shoot at Mark Hortman, and surveillance video from the Hortman residence showed a masked individual in a police-style tactical vest, blue shirt, and cowboy hat, announcing himself as a police officer before shooting John and Yvette Hoffman. A person familiar with Boelter identified him in the surveillance footage. Inside the Ford SUV left at the Hortman residence, police found 3 AK-47 assault rifles and a 9mm handgun, with Boelter listed as the purchaser of at least 4 recovered firearms. There is a notebook containing a hit list of approximately 50 to 75 names, including Melissa Hortman, John Hoffman, Governor Tim Walz, U.S. Representative Ilhan Omar, U.S. Senator Tina Smith, and Attorney General Keith Ellison, all Democrats. The list also included abortion rights advocates, Planned Parenthood locations, and officials from neighboring states. In the surrounding area, police recovered a ballistic vest, a disassembled 9mm handgun, a hyper-realistic silicone mask, and a gold police badge corroborating the impersonation tactic. And apparently there's some text messages. Boelter's 6 a.m. text to friends on June 14th, apologizing and suggesting he might die, align with the timeline of the attacks and indicate, obviously, premeditation. Now, the discovery of Boelter's Buick sedan and a cowboy hat, matching the one seen in the video footage, further tied him to the crime scene and his subsequent flight. So the combination of the direct observation, some forensic evidence, and Boelter's own communications provide a pretty robust case for his involvement. Now, the hyper-realistic mask and the police impersonation suggest meticulous planning consistent with the federal stalking charges, not to mention after deliberation. And whether there's involvement of others, police have stated that they are confident that Boelter was acting alone in carrying out the shooting, but they're investigating whether he was part of a much broader network. We'll have to wait and see on that. But what about his wife? Boelter's wife and relatives were stopped by law enforcement near Onamia, Minnesota, in a vehicle containing passports and cash. They were questioned and apparently quite cooperative, providing information that aided the investigation, but no evidence suggested they were involved in the shooting, and they were not taken into custody. Now, if they knew where he was and they were going to provide all this cash and passports, it could be potential accessory after the fact. We'll have to wait and see. And then the Minnesota Bureau of Criminal Apprehension Superintendent Drew Evans noted that while Boelter was in contact with individuals while on the run, there's no evidence that he received assistance in executing the attacks or evading culprits. Now, the FBI is exploring whether Boelter's actions were influenced by or connected to a larger group, particularly given the political nature of the list. However, no concrete evidence of a network has been disclosed. and the absence of immediate evidence implicating others suggests that Boelter planned and, well, probably executed the attacks independently, though the investigation is ongoing. Possible motives. Investigators have not publicly confirmed a definitive motive, citing the ongoing investigation, but several factors point to politically motivated attack, right? Governor Tim Walz describes the shooting as politically motivated, referred to them assassinations, and all the victims were prominent Democrat-affiliated party members within the Democratic Farmer Labor Party. The hit list included other Democratic lawmakers and abortion rights activists, suggesting targeting based upon political ideology. Now, the inclusion of abortion rights supporters and Planned Parenthood locations on the hit list align with Boelter's targeting of lawmakers like Melissa Hortman, who in 2023 helped pioneer protections for abortion rights in Minnesota. This may indicate opposition to liberal policies on reproductive rights. Boelter's registration as a Republican voted in the early 2000s, and the Democratic affiliation of his targeting suggests, well, possible ideological conflict. His text to friends expressing regret but not specifying his actions could reflect personal or ideological turmoil. While a notebook with names and other thoughts was found, authorities have not identified a succinct document outlining Boelter's motives, distinguishing it from a traditional manifesto. Acting United States Attorney Thompson noted dozens and dozens of names of hundreds of pages, but no political screed. So this is going to be an interesting one. My guess is acted alone, doesn't like a particular policy, but you change that at the ballot box, not by gunning down individuals. That's never right. Next on the docket, it's always about respect. This story comes from Colorado. I've done lots of bar shootings over the years, ladies and gentlemen. Not me personally, but I've represented people where there's been involvement with shootings at bars. We have a Lodo district down here. One I can remember years ago where literally the guy was disrespected, went to his car, came back in and started firing on people there in the bar. And all of these cases, I don't get it. Always about respect. Somebody's been disrespected, and so they're going to go shoot the place up. Anyway, a 30-year-old man was sentenced to more than 1,000 years in prison following a shooting in 2022. Now, in 2022, Efrain Sanchez left the bar Rancho El Corazon and returned wearing a mask and carrying a rifle. Police said that Sanchez was seen on video leaving the bar and feeling disrespected by another person. The video showed him firing several rounds at people outside of the bar before firing more rounds into the inside of the building. Anyway, he fired 28 rounds in total that night. He shot bullet after bullet, causing pain and panic, said the chief deputy district attorney prosecuting this guy. These are innocent victims with forever reminders of the defendant's actions. And back in April, Sanchez was convicted on 50 counts of attempted murder, 2 for every person at the bar that night. The judge also ruled that Sanchez would serve 40 years each for the 23 other people at the bar that night. He was sentenced to a total of 1,016 years in the Colorado Department of Corrections. Next, a quick update on that horrific story out of Washington State. So back in June 2nd, 2025, the bodies of Paitlin Decker, age 9, Evelyn Decker, age 8, and Olivia, 5, were discovered at a remote campsite in a national forest near the Islas Creek, Washington. The campsite, located approximately a half mile from the National Forest Service Run Rock Island campground, was the scene of alleged triple homicide. Now, court documents indicate that the girls were found with plastic bags over their heads and zip ties down a small embankment near their father's abandoned white GMC truck. So the suspect, this Travis Decker guy, a former U.S. Army soldier, is the primary suspect. Decker, who had been homeless since the fall of 2024, is believed to have taken his daughters during a routine scheduled visitation on May 30th from their mother, Whitney Decker, in Washington. When he failed to return the girls as scheduled, Whitney contacted police, prompting a search. Decker had been at large since May 30th and is considered armed and dangerous. Now, the sheriff's department up there says he's dangerous, particularly after a fresh bullet casing was found near the campsite. Investigators reported the following. First, the truck contained several personal items, including blankets, car seats, and food, with 2 bloody handprints on the tailgate. Now, Decker's wallet was left behind. The campsite showed signs of extended use, with discarded Memorial Deal leaflets from local stores, a weathered orange tent, a blue cooler, a recently used fire pit with a log pile, and a makeshift lean-to constructed from tin and wood. There was also plastic bags and zip ties initially found at the scene. They were later removed. Now, Decker is believed to be hiding in the mountains, a rugged 50-mile stretch there of terrain extending to the Canadian border. And on June 9th, police reported a possible sighting of a man matching Decker's description near Blewett Pass, which is 15 miles south of the campsite. But by June 11th, the sheriff confirmed that footprints and personal items potentially belonging to Decker had been found, but the suspect remained at large. Now, the United States Marshals and the Border Patrol have taken over the search operations while the Sheriff's Department focuses on the criminal investigation. Now, Decker, an experienced survivalist, reportedly lived off-grid for 2 months previously. His ex-wife, Whitney Decker, stated he had been diagnosed with borderline personality disorder and had faced mental health challenges. Now, despite this, she noted that Decker had a good reputation with his daughters and had never failed to return them on any prior visitations. Whitney described Decker as unusually quiet during their last interaction on May 30th, and he had mentioned plans to rehome his dog due to financial and housing difficulties. Now, Thomas Decker, Travis's older brother, expressed absolute shock in an interview, stating that the suspect's actions were inconsistent with the brother that he knew. He described Whitney as devastated beyond belief and emphasized the family's disbelief given Travis's apparent love for his daughters. Now, the sheriff stated, "We believe we're closing in on his trail. There is nowhere he will be able to go where we don't have units waiting for him." He highlighted the challenges posed by the mountainous terrains with peaks of up to 9,500 feet covered in dense alpine forest. And even with his survival skills, that'll be tough. So as of today, Travis Decker remains a fugitive. Authorities urge anyone with information to contact the Chelan, Chelan County Sheriff's Department. Horrific story. Horrible. Couldn't imagine somebody, just a father doing that to their kids. Just unbelievable. Next, let's talk about Sean Diddy Combs. A federal judge dismisses a juror in the Combs sex trafficking trial amid some residency concerns. So what could be described as a significant development in the ongoing sex trafficking trial of Sean P. Diddy Do-It Combs? A federal judge dismissed a juror on Monday after concerns arose that the juror misrepresented his state of residency during jury selection. Now, the dismissal sparked allegations of bias as the defense accused prosecutors of targeting a black juror. Now, according to reports, the dismissed juror, identified as juror number 6, initially stated during jury selection that he resided in the Bronx with his fiancée. However, he later disclosed to a court staff member that he had recently relocated to New Jersey to live with his girlfriend. When questioned further by the judge, the juror's inconsistent responses deepened some suspicions. Ultimately, the judge concluded that the juror was shading answers to secure a place on the jury and continued to do so under scrutiny, leading to his ultimate dismissal. Now, juror number 6, a black man, was one of only 2 black men on the jury, and his replacement is a white man. This prompted Combs' defense team to accuse prosecutors of attempting to remove a black juror, raising concerns about racial bias in the jury process. Now, the court has not publicly addressed these allegations in detail, but the incident has added to the contentious atmosphere surrounding the high-profile trial. Now, for those who aren't familiar, Mr. Combs was arrested back in September of last year outside of a Manhattan hotel following a federal raid on his home in Holmby Hills, California, and Miami in March of last year. The raids were part of an ongoing sex trafficking investigation, which gained momentum after former girlfriend filed a multi-million-dollar lawsuit in November of 2023, which Combs paid like the next day, accusing Combs of sex trafficking and abuse. The lawsuit was settled, like I said, the following day, but additional allegations and lawsuits soon followed. And then, of course, you had the hotel surveillance footage that allegedly depicted Combs assaulting Ventura, which he admitted he did, so it wasn't really allegedly. Anyway, Combs issued a public apology stating he had sought therapy and rehabilitation, expressing remorse without seeking forgiveness. However, the fallout from the footage led to further lawsuits, including one from April Lampros, who accused Combs of sexually assaulting her on 4 occasions between the mid-1990s and early 2000s. At least 30 lawsuits have been filed against Combs, alleging sexual abuse or facilitation of such acts. Now, none of that certainly helped Mr. Combs in trying to get bond. He's been denied bail 3 times, and the judge says that he is a serious risk of witness tampering. That decision reflects the gravity of the charges and the prosecution's concerns about Combs' influence and resources. So we'll just have to wait and see. The plot thickens. I got a big problem with jurors that lie to stay on juries. Usually jurors lie to get off of juries. So if you're lying to stay on the jury, well, guess what? Somehow you're not going in there as a fair and impartial juror that could give a fair trial to both sides. Remember, you have to have a clean slate. You can't be biased for the prosecution or the defense. You can't have tilted that scales. You have to reserve judgment until you hear all the evidence in the case. And if a federal judge is like, you're kind of shading your answers here to stick around, I think I'm going to let you go. Guess you won't be able to write that book, juror number 6. Next on the docket, remember the Crumley case? Jennifer Crumley? Well, her attorney got sanctioned. What in the heck happened? So they're in Oakland County, Michigan. Michael Desi, the attorney representing Jennifer Crumley, was fined $1,657.70 by Judge Cheryl Matthews for filing an improper motion. The motion, submitted back in March of this year, sought to remove the prosecutor, Karen McDonald, from Crumley's case, alleging misconduct, including the suppression of a secret proffer agreement with 2 key witnesses and the use of public relations firms to smear the Crumley parents. The fine matched the amount that Desi was reimbursed for filing the motion, and he was ordered to pay it by July 14th of 2025. Now, the judge has denied the motion back in April, stating that the court lacked jurisdiction to decide on it and that it violated the court rules by being filed for an improper purpose. McDonald defended her actions, asserting that the motion was legally improper and disrespectful to the victims and the court, emphasizing that Crumley's conviction stemmed from her own actions. Now, Desi responded to the sanction on June 10th, announcing an appeal and vowing to continue addressing allegations of prosecutorial misconduct. He said, quote, "I will not be bullied or intimidated into being silent about prosecutorial misconduct or how Jennifer Crumley was denied a fair trial," end quote. Now, Jennifer Crumley, along with her husband James, were convicted of 4 counts of involuntary manslaughter related to their son's actions in Oxford High School shooting back in November of 2021. It resulted in the killing of 4 students. Both parents were sentenced to 10 to 15 years in prison on April 9th of 2024, and the sanction is part of a series of legal maneuvers by Crumley's defense as she seeks a new trial or dismissal of the case. A significant issue involves undisclosed proffer agreements between the prosecution and 2 school employees who were key witnesses in the case. These agreements, revealed after the trials, prompted arguments from Desi and James Crumley's attorneys, Alana Sharon, that the defense argued these agreements constituted immunity and that should have been disclosed, while the prosecution maintained that there were not immunity, but assurances to obtain truthful information. I don't know what you call that. Anyway, the judge indicated during these hearings that all discovery violations likely occurred, that she has not yet ruled on the new trial motion. Matthews is simultaneously addressing both Crumley's motions for a new trial to ensure the coordinated response. Desi has also filed a complaint alleging delay in Crumley's appellate rights, prompting a public statement from the Oakland County 6th Judicial Court. The court's next steps includes resolving 3 motions with potential implications for the Crumley's convictions and the broader case. Listen, if it wasn't turned over and you had some sort of secret agreement, you have to turn that over. That's a Brady violation. Now, would it have made a difference? I don't know. But there's a reasonable possibility it could have made a difference, that you weren't going to charge the people that worked for the school that had the same more recent contact with the Crumley kid. Why aren't they charging that guy? If that's where you're going to go, you should have intervened. Charge the whole school staff. But you got to go back to my previous things we talk about. We start getting to a negligence standard in the legal system, ladies and gentlemen. They're coming for you. Well, you should have done this. You should have done this. Scary, scary, scary. Particularly when they all considered it a novel, unique legal theory. Novel, unique legal theories are not meant. No. Here's the crime. You knowingly did it. That was it. To get into negligence, that's so that everybody can become a criminal, ladies and gentlemen. Next, Donna Adelson says she needs a new venue. That's right. Donna Adelson and her defense team were in court Friday morning asking a judge to move her upcoming trial out of Tallahassee. Now, the hearing lasted nearly 3 hours before concluding just before noon, with the Leon County Circuit Judge Stephen Everett saying a written ruling will be issued once he reviews all of the exhibits that were admitted as part of the hearing that has yet to review them all. Anyway, Adelson's defense team claims extensive media coverage of the case, which is now dates back nearly 11 years, makes it impossible for her to receive a fair trial there. The media coverage in this case warrants a change of venue, the attorneys argued as they wrote in their motion for change of venue. Not only has the pretrial publicity been extensive, but it has also been highly inflammatory and prejudicial towards Ms. Adelson. During the hearing last Friday, the defense attorneys announced that if the court decides to defer the ruling or deny the change of venue motion, they will request additional peremptory challenges. Adelson is the latest to stand trial in the murder of her former son-in-law, FSU law professor Dan Markle. Her son, Charlie, his ex-girlfriend, Catherine Magbuna, and hitmen Sigfredo Garcia and Luis Rivera have already been convicted in the murder for hire plot. Now, Miss Adelson cannot receive a fair trial by an impartial jury in Leon County. Her attorneys wrote when they requested the change of venue, they claimed that the jury pool in Leon County is tainted by preconceptions, bias, and prejudice against her. One of the witnesses who testified Friday was James Todd Murphy, president of a company called TrueScope North America. Its website describes it as an AI-powered media intelligence and lists media monitoring and social media listening among its specialties. Mr. Murphy previously testified in the change of venue hearing in the case of Brian Kohberger, who was accused of killing 4 University of Idaho students there in November of 2022. Kohberger's trial, which is coming up later this summer, August 11th, was ultimately moved to Ada County, some 300 miles away. And Donna Adelson's defense attorney, who appeared in court earlier this week to update the judge on trial preparation, asked the circuit judge to take judicial notice of the media coverage the expert witness has complied. He said this is to the extent that articles were run or they were broadcast in some way, and this is really not subject to dispute. It's what is the value of it. Think the argument points. Anyway, the prosecutors are expected to fight the request to move the trial out of Tallahassee. The prosecutors pointed out that the attorneys were able to select juries in the trials of Donna Adelson's co-defendants. And our position is, the prosecutor said, is that she can be given a fair trial here in Tallahassee. And that's based primarily on the fact that we've been able to successfully pick a jury in related cases. The prosecutor said that she's confident that they can find capable jurors once again. And normally that's the case, ladies and gentlemen. If you can't get a jury seated by the jurors that you have there, that's normally when it's moved. Yes, the Kohberger case was a little different. This case has been going on forever down there, but I bet you could still find people on the street that have never heard of Donna Adelson or anything regarding this case. Next on the docket, this day in legal history. On June 16th, 1866, the U.S. House of Representatives passed a joint resolution proposing the 14th Amendment to the Constitution, obviously a legal landmark milestone that profoundly shaped the American criminal justice, civil rights, and the constitutional law, right? Because it made the Bill of Rights applicable people in the states. Remember, it's a federal law, but then they had to say, oh, we're going to apply it to the states. Big news that it was. On June 16th, 1919, federal agents were probing anarchist mail bombings during the first Red Scare, leading to arrests and shaping sedition laws under the Espionage Act. Why is it that when you always have this unrest, it's anarchists and communists? One doesn't want any government and one wants total control. But you know what they want to know? Definitely for sure. Total destruction of whatever system that they're protesting. Usually free market capitalism, democracy, constitutional republics, those kinds of things. And on June 16th, 1935, Congress passed President Roosevelt's New Deal legislation to start a recovery program from the Great Depression. Yes, ladies and gentlemen, if you don't like big government, you can thank FDR and that Congress, because before they kept getting it thrown out in the court saying the federal government has no authority to do any of this under the Constitution. Show me where, point to me where. All this is reserved to the states. But remember, what did FDR threaten to do when he didn't get his way? He was going to pack the court. And the court got scared and it said, fine, I guess the federal government can do these various programs. And they haven't stopped spending since. On June 16th, 1944, a 14-year-old George Stinney Jr., a black youth, was executed in South Carolina for the murder of 2 white girls. His conviction was vacated in 2014 due to the lack of due process, highlighting racial injustice in the legal system. 14 years old, ladies and gentlemen. Horrible. On June 16th, 1968, Congress finalized the Omnibus Crime Control and Safe Streets Act, which was signed in June, funding police modernization and expanded wiretapping laws. You can trace it all back, and your privacy's never been the same again. On June 16th, 2000, a federal judge issued a preliminary injunction against Napster. Remember them? Ordering it to stop distributing copyrighted music, marking a landmark case in digital copyright law. Remember, you could just download anything on Napster. I remember my kids were like, this is the best thing ever. And then they got shut down. But then the guy went on to bigger and better things and helped guide Facebook through the early days. Can't remember his name, but it was in the movie about Facebook. I can't remember his name. It doesn't matter. Anyway, next, our legal quote of the day involves free speech. We love free speech, ladies and gentlemen. We love all of the amendments to the United States Constitution. You got to look at all of them. So the First Amendment to the United States Constitution articulates the right to peaceful protest, stating, quote, Congress shall make no law abridging the freedom of speech or of the press or the right of the people peacefully to assemble and to petition the government for a redress of grievances. Now, obviously, this underscores the fundamental protection of peaceful assembly and expression in public spaces, right? And the First Amendment protects your right to express your opinion, even if it's unpopular. In fact, the First Amendment's there for the unpopular ideas, right? If everybody just went along with it, well, or you had to, I guess that'd be like a dictatorship. So the First Amendment protects unpopular speech. But this right doesn't extend to libel, slander, obscenity, true threats, or speech that incites imminent violence or lawbreaking. So this highlights that while peaceful protests in public forums like streets or parks enjoy strong protection, actions that disrupt public order or safety, such as physically harassing others or engaging in violence, cross into the unprotected territory. So remember, the right to peaceful protest is robustly protected, but not absolute. And the line is crossed when protest involves incitement, threats, violence, or violation of reasonable regulations, as these actions undermine public safety or the rights of others. Don't take my word for it. It's the United States Supreme Court rulings. And finally, ladies and gentlemen, what you've all been waiting for, the dumb criminal of the day. Please meet Hassan Rabbit and his wedding day blunder. Ladies and gentlemen, gather round for the latest installment of the Dumb Criminal of the Day, where we shine a spotlight on those who make spectacularly poor life choices. Today's star is Hassan Rabbit, a Detroit man who thought a wedding caravan was the perfect stage for his own action movie, complete with live ammunition. Picture this, a sleek purple Lamborghini Huracan, rented for a cool $1,500 a day, cruising down a Michigan highway as part of a wedding party's convoy or high-end sports car event. That's the vibe, right? Pure celebration. The destination, the Royalty Manor Banquet Hall in Dearborn Heights for a joyous reception. But Rabbit, riding shotgun, decided to elevate the festivities with a move straight out of a low-budget crime flick. As the convoy tore through the streets, already drawing attention for their reckless driving, Rabbit allegedly whipped out a firearm and fired celebratory shots into the air. because nothing says congratulations like gunfire on a public highway, apparently. Anyway, a witness, clearly unimpressed by Rabbit's antics, caught the whole stunt on the dash cam and promptly dialed 911. Reporting this guy is shooting guns in the middle of a Ford road. Kudos to the citizens for not mistaking this for a bizarre new wedding tradition. Police were able to trace the purple Lambo to the banquet hall where they found the wedding party less than cooperative, perhaps too busy practicing their I saw nothing faces. The car seized as potential evidence was later returned to the Dream Luxury Car Rentals, who must be thrilled. Their $1,500 a day ride doubled as a prop in Rabbit's misadventures. Now, thanks to a tip from a confidential source with a decade-long track record of spilling the beans, police zeroed in on Rabbit as the trigger-happy suspect. And the 2020 Lamborghini, meanwhile, wasn't the only pricey rental in the wedding caravan. A yellow Lamborghini, also a $1,500 a day rental, was part of the fleet but wisely stayed out of the gunfire spotlight. Rabbit, now facing a felony charge for reckless discharge of a firearm, clammed up when questioned by police. He is out on a $1,000 personal recognizance bond and has a pretrial hearing for June 25th. Now, we'll give him the presumption of innocence, but one can only hope that he leaves the firearms at home this time. So here's to Hassan Rabbit, our dumb criminal of the day, who turned a wedding celebration into a one-man fireworks show, minus the permit, the brains, or the applause. Next time, Rabbit, maybe stick to tossing some rice. All right, ladies and gentlemen, that's all we have for you today. Okay, still no verdict in the Karen Reed case, but when it does, we'll bring it to you live. Thanks for watching. We'll see you next time. And remember, the Constitution matters.